is we emerge from a shared history that has got inflicted scars on us. As we would remember yesterday, our esteemed judge yesterday took us through to the history of Africa. In this shared history, as I say, it has got scars that we carry unaware or at times even are aware. And it is these scars that have led us to be in this space where we are talking about Pan-Africanism. And this Pan-Africanism comes in sort of distorted ways, but the whole spirit behind it is to actually have to go back to the Africa that we once had, to the Africa that graced this world as a leading power. Today, I'm going to locate our lecture of trade liberalization and tariff concession in the midst of the geopolitical crisis, epitomized by a raft of orders that we witnessed one day when one power came into power. Suddenly, there were a lot of tariffs that were being released from the US. I locate this lecture because to actually highlight how significant, how important these tariffs are, and how they can be used, they can be manipulated to be weapons that can actually set us back to positions where we don't want to be. For those who come from Lesotho, maybe from, and I myself is from Zimbabwe. Zimbabwe was one of the first countries to respond to the tariffs that were actually being released by the states. We actually offered them zero tariff rates because we recognized our point as a weak nation, and we were the first to go, and we became a butt to the jokes that were being said globally about us actually offering the US zero tariffs. And Lesotho actually received one of the highest ad valorem tariffs, 50%, meaning that all their exports to the US were going to be levied 50%. And what effect did that have? Lesotho saw the close down of their factories and 20,000 people being laid off. And that brought untold suffering to the kingdom. So these tariffs released uncertainty. So today I want us to really grasp the importance of the tariff concession. Then coming on to the AfCFTA, we also realized that it is these tariff concessions and the rules of origin that actually delayed the onset of trade. Why? Because of the significance of tariffs. Once it's not properly attended to, and within the context of trade liberalization, that can bring a host of problems that we do not anticipate, like closing factories, like maybe certainly having a flood of goods into your country, and jobs become the casualty. And today, as I speak, there's what we call a liberalization day in the US. Those tariffs have been reversed, and the offices in the US are inundated with claims on refunds on those tariffs. And as far as our trade liberalization and tariff concession is concerned under the AfCFTA, I'm afraid we don't have that provision that once the tariffs are done, then maybe once the tariffs are in place, you cannot come and say, no, in 2021, I didn't have the tariff offers in place, and now I want to claim a refund. Right. And in the midst of that as well, the geopolitical crisis, we've got a plethora of various trade agreements also coming into play. We have got your BRICS, we have got the China Belt Road Initiative, the EU's Global Gateway Initiative. All these, they can actually mitigate the implementation of the AfCFTA. Where does this put us as Africa in the AfCFTA? So where this actually puts us in the basis of the AfCFTA is when I talk about that we have to look at this tariff concession. Unfortunately, it had to take a long time. The protracted negotiations had to take place in order for state parties to be satisfied and feel safe that their industries were not going to shut down because of maybe a shoddy approach towards the tariff concessions. And I'm going to quote Africa is running as epitomized by this video of the cheetah, which I love so much. The cheetah is associated with Africa, and the cheetah is the fastest running animal. And when we are saying against this background that I've painted to you of gloom from the geopolitical tension, but you still have to run, as coined by Professor Thandika Mkandawira, that Africa has to run. We have to do the catch-up game as Africans in order for us to claim the position of being one of the powers in the world. So this theme Africa is running, the professor coined it because he had also noticed how these superpowers, how these countries were actually behaving as the parents of Africa. The programs that were being released in Africa were actually paternalistic in nature, and because of that, we were always left behind. You remember the ESA program that actually derailed a lot of progress in Africa, and countries were left to wallowing in poverty, only to discover that this program was not ideal for Africa. And because of that, we just have to run. Africa will keep on running. Unfortunately, because Africa has got the resources, we've got the skills, we've got the demographic dividend, it is possible. Africa has to run, and we have the capacity to run, as epitomized by the cheetah there. Why does tariff liberalization and Church of Concessions matter under the AFCFTA? Can't I have the laptop here? This is becoming a challenge. Why does tariff liberalization and Church of Concessions matter under the AFCFTA?
Sorry, we had to improvise.
Is there anything there? Oh, okay. Yes, before we delve deep into the lecture, I need to also share with you the outline is being shown there. We are going to actually go into the historical background of which thank you. Our outline here, we are going to go through the historical background of which I've done a bit of it there, and it has also been covered extensively yesterday. It was covered extensively yesterday. And we are also going into the nature of trade agreements. We're going to look at the protocol of goods and services, but for our lecture today, we'll be concentrating on the protocol of goods. And we're going to look at the key aspects of tariff liberalization and tariff concessions, then the link between tariffs and rules of origin, and the legal implications. In the past, before modern trade agreements such as the AFCFTA, there were systems of exchange such as barter, which were governed by principles of fairness, trust, and mutual benefit, a hallmark of fair trade practices. I'm just going to skip these slides because I feel justice was done to the objectives of the AFCFTA, how it all came about. And today we have the advantage of just getting straight into the lecture. Tariff concessions come about because there would have been a trade agreement between state parties. And once the state parties agree, then they move on to tariffs and rules of origin. The tariffs are there to actually determine the rates of duty that will be paid to those particular products that have been agreed upon. And for the purpose of our discussions, we're going to be talking about the preferential trade agreements. In the context of today, the AFCFTA, it is a preferential trade agreement because from it flows the products' rights, if I may put it that way, that particular goods that have been agreed upon in terms of rules of origin, they will enjoy preference, they will enjoy preferential treatment in the form of reduced rates. Captured there in the case of a free trade area as in the AFCFTA, it is a group or two of more customs territories in which duties and other restrictive regulations of commerce are eliminated for products originating in those countries. So already there, bear in mind that the originating rules, that's where we talk about rules of origin, your certificates of origin, and that has got a lecture, dedicated to it. And these trade agreements, they can be bilateral, regional, and multilateral. You remember in my background introduction on the lecture, I spoke about the BRICS, which this is a regional economic bloc that is actually under discussion with some countries who are already part of, and we've got AirPass, we've got other regional agreements. We talk of Africa as being a spaghetti bowl of trade agreements. So all these come as trade agreements which have got rights on products like preferential treatment, which I'm talking about today. And why these trade agreements is for mutual benefits to the parties. It's also important to remember that agreements are entered into by governments, and then governments create an environment for traders to conduct businesses. And it's up to businesses, it's up to private sector to actually keep a tab on these developments, especially on tariffs. When governments are negotiating tariffs, they don't do it willy-nilly. They have to conduct consultations within their private sectors and their business organizations, such as chambers of commerce. We should present a position to the government on particular products that are being negotiated on. So, and those products actually constitute the tariff offers that we are talking about today. The AFCFTA is premised on the acquis principle as it builds on the existing regional economic communities recognized by the AU. We dealt with those and we discovered that there were actually 8 regional economic communities that were recognized by the AU. And as our judge took us through yesterday, we discovered that this is not as simply as I put it here. In those regional economic communities, there are sub-communities, there are sub-agreements, there are sub-bilateral agreements, which actually complicate trade within Africa. And it is on that principle that the AFCFTA itself has been premised on this acquis principle to make life easy, meaning that whatever is going on within those regional trade agreements, if whatever is offered by a regional trade agreement is better than what the AFCFTA offers, that regional agreement would actually have the day in terms of trading in goods. The AFCFTA is a flagship project of Agenda 2063 and acting as a conduit to deliver the attainment of the SDGs through the BIAT Action Plan 7 clusters. The Boost Inter-African Trade Action Plan is very important because it's supposed to actually aid the AFCFTA to take off. And amongst the 7 clusters, and what comes to mind now is, to me, what comes to mind right now is the trade facilitation that has actually been taken seriously by most countries in order to create an enabling environment. But there are also other 6 clusters which are there, which are supposed to also be considered by countries in order for them to actually relatively liberalize the tariffs. The AFCFTA protocol on goods is regulated by the following annexes. We've got the schedule of tariff concessions, which is the subject matter of today's lecture. We've got rules of origin. We have customs cooperation and administrative assistance. We've got trade facilitation. We've got non-tariff barriers. We have technical barriers to trade. We've got sanitary and phytosanitary measures. We've got transit, and we've got trade remedies. The schedule for tariff concessions, you cannot actually speak about them in isolation from the rules of origin, because the schedule of tariffs themselves, I always liken it to be like a toll booth, and the rules of origin are actually the gatekeepers. So it is important to get these 2 right. The rules of origin are there to actually determine the nationality of the product. And once the nationality of the product has been determined, then we move on to see whether the goods have been correctly classified. Are they appearing on the offers that have been agreed upon by the AFCFTA Secretariat? And usually these 2 areas, more often than not, they're actually areas of dispute in such a way that at times governments or companies or maybe even private organizations, they find themselves in these disputes that the courts are actually approached in order to arbitrate on the issues that will be raised before them. So it's important to notice that it is important for businesses to actually understand when they are making their tariff offers what they are getting their governments into, and also to understand the critical importance of the rules of origin. Then these 2 annexes, schedule of tariff of concessions and the rules of origin, are actually administered by customs. This is where the customs administration have a role to play, because the customs administrations, they are the entities that are skilled to know how to correctly classify the goods. They also are the entities that know the statistics relating to particular goods, because as goods are actually being imported under that particular tariff, it's important for governments to know how much in terms of revenue is actually being foregone by those tariffs, and how much in terms of revenue is actually being maybe gained because of that particular tariff. Because it's either 2-way. If a particular tariff is causing an injury to the domestic market, businesses got the right to approach the government and tell them what is happening. And this is where the government maybe starts to move and take a position of what we call maybe becoming protectionist, of which is not going to be encouraged under the AFCFTA. But at times, as we know, once tariffs are reduced, there's some form of maybe regulation that comes into counter. I'm not saying that it happens in all the countries, but it's usually normal in trade. That's once a tariff is maybe removed or adjusted such that revenues are lost. Usually, there's a way how they take back the revenue that has been lost. But it cannot be easily seen, and how it can be easily how customs gets to be involved is because they have the statistics, the rates of what is actually happening to that particular tariff. And the rules of origin as the gatekeepers, they are there now to actually safeguard the uptake of those reduced tariffs. You can imagine where a situation when the rules of origin are lax and all the imports are coming in to come and actually claim on those zero rates of tariffs. So that is why, again, the negotiations on those two actually delayed the whole agreement, because all the state parties wanted to be really sure of what is happening. Then trade facilitation, as I mentioned, it is also enlisted in the BIAT plan of action on how the trade environment is going to be enabled in order for the tariffs that have been agreed on to be claimed and the rules of origin to be complied with. At times we find that in countries or in state parties, it is difficult to actually access the reduced tariffs through the stringent rules of origin that are actually gatekeepers towards those tariffs. Then there's the non-tariff barriers. That is going to be handled by one of the presenters, and then the technical barriers to trade and sanitary and phytosanitary measures. But for the purpose of our lecture today, I'm restricting myself to the schedules of tariff concession and the rules of origin per se, and the customs cooperation and administration assistance, which plays a role, which is the one that moves the needle between these two annexes that I am talking about. In terms of the law, the protocol on goods definition or schedule of concessions means the schedule of tariff concessions, a list of negotiated specific tariff concessions and commitments by each state party. It sets out transparently the terms, conditions, qualifications under which goods may be imported under the ASFTA. So let's note the words here: transparent and the conditions and qualifications that actually accompany the schedule of tariff negotiations that are done as regards the tariffs. And in terms of the AFCFTA tariff concessions, unlike what has happened in the United States, state parties shall not be required to refund any customs duties collected on imports from other state parties between 1st January 2021 and the first day of implementation of their provisional schedules of tariff concessions. Practically, what can actually happen is the countries actually offered the Secretariat, the AFCFTA Secretariat, their tariff schedules at varying times. And because trade began on January 2021, maybe an organization can come forward and say, since these goods are now attract a zero rate percentage, can I have a refund that is actually being backdated to January 2021? Under the AFCFTA, that is not possible in terms of the law. These tariffs are not going to be applied in retrospection. And we've got detail there on what actually was agreed upon by the state parties on the list of tariff concessions and commitments under the prescribed modalities shown below, which are legally binding. These are the tariff modalities actually regulate the tariff offers. It was agreed upon by state parties on the categories of which trade liberalization was going to occur. We've got category A, category B, and category C. And category A, you've got 90% liberalization, which is going to be done between 5 and 10 years. 5 years for developed countries, and 5 years and 10 years for least developed countries. And these are general goods. And this liberalization is actually fast. There is no negotiation on that. It's between those prescribed periods when of which 90% of liberalization must have occurred, and the goods have been identified, and the state parties have identified the products and offered and submitted them to the AFCFTA secretariats. And then there's category B, sensitive goods. Here we're looking at maybe the state parties were actually looking at their sensitive sectors, maybe like in food production or maybe in agricultural products. And here the liberalization is going to be at 7%. Within 10 years for non-LCD and 13 years for LDCs. Then there is category C, protected goods, where here this sector is actually closed for negotiation. These are sensitive sectors as far as state parties are concerned, according to their own analysis and identification. And it's been pegged at 3%, and no liberalization is going to take place here. And what it means is that for the longest time, there was not going to be a review on this sector that is closed. And also research shares that with trade liberalization, that's why we are having these categories. In the short term, a lot of countries suffer. There are a lot of setbacks. You can imagine when your borders are being opened to goods from all over, maybe all over the continent. And the immediate impact on those is that some businesses might close. And once that happens, countries actually will be taken back to a position where there's also joblessness, which is not the spirit of the AFCFTA, because the AFCFTA is there to actually create jobs through this enabled trade environment. So that's why we have maybe this sector which is closed. Maybe we're looking at your infant industries as well that you need to protect from the consequences of the short-term consequences of trade liberalization. The status of these tariff offers. So far, we have got 49 countries that have submitted their tariff offer, with a remaining of 5 countries still to submit. But we know that, as we discussed yesterday, trade has actually begun with the Guided Trade Initiative, because what it means that those countries, they've actually completed their tariff offers, and these tariff offers, they've actually been technically verified by the AFCFTA Secretariat. This is another very important component, that your tariff offers, they are not automatically accepted once they are submitted to the AFCFTA. They have to go through the checks and balances, and once they satisfy the technicalities that are outlined by the Secretariat, then your tariff offers are accepted, then maybe you can begin to trade. And also, I must mention the principle of reciprocity. Negotiations on tariff liberations allow reciprocity between state parties regarding technically verified tariff offers. What it means that whatever you negotiate, this is trying to create a balance. Remember, I also spoke about fairness in the definition of tariff offers. The trade has to be fair and transparent. So the tariff offers are reciprocal. Whatever you decide as a state party, that's what you are also going to get from the other state parties. I have shared on the slides the website. We have what we call now the e-tariff. There's so much that is going on. So in order for us to be updated as businesses and as the legal fraternity of what's happening in terms of the tariffs that we are discussing today, there's this website which has been done by the AFCFTA Secretariat. It shows about the tariff rates, the reduction over time, and the country offers. So it's also important for the businesses that before they actually maybe identify a particular product, they will need to go to visit this website and see the advantages that they have over the particular product they want to import or export. Benefits to businesses. The benefits are obvious. We've got competitive sourcing for international inputs from the state parties. We've got enhanced opportunities for state parties to industrialize, thereby promoting interregional trade within Africa. Africa trades with outside the world more than it trades within itself. This was dealt with extensively yesterday. And also, we've got the opportunity of developing the regional value chains. Once we have our tariffs adjusted, it means the MSMEs can actually identify a particular value chain, analyze it, and actually come up with an entry strategy into that regional value chain. And that helps Africa in its program of Africa integration. Rules of origin. This lecture is going to be dealt extensively by the presenters that are coming after me, but for now, we're just going to skim at a high-level point. Rules of origin tariffs define market access due to the conditionality element that requires origin compliance, accurate classification for the product to qualify for preferential treatment, and a legal entitlement on production of a prescribed certificate of origin. As I said earlier, that this becomes a contested place because in order for goods to qualify, It's not a question of someone coming to you and convincing you that my goods qualify, they are from this particular country. This is where the Customs Administration also plays a very significant role. They have to go out and investigate the particular product that is being manufactured and ensure that whatever is going in there qualifies in terms of local content for that particular product. And because of that, at times, a debate ensues or a misunderstanding can arise as to the qualification of the product as to be originating from that particular country. And this is where we are talking about that the rules of origin confer nationality of the goods. And that nationality is done through a process that involves going into the industries there and investigating what is actually happening, compiling the schedule cost and everything that actually make up that product. And in that, at times, even you find that even some organizations, they're even reluctant because it really exposes their day-to-day operation of businesses. And because of that, they might even shy away from actually taking advantage of the preference that is there because of this, of the exposure, of the inherent exposure that the business will be made to experience. But on the whole, the certificate of origin becomes the legal document. A prescribed certificate of origin becomes the legal document that one has to submit in order for their goods to qualify. If rules of origin are not defined, tariff concessions cannot be applied effectively. So you can see that already this area is, can be an area of conflict, but because the rules of origin themselves are there to be gatekeepers, but not to maybe become a non-tariff barrier, because there's a thin line between maybe enforcing compliance and actually turning that compliance to be a non-tariff barrier. So, but the stringent is also required because at the end of the day, you have to safeguard the domestic market from being flooded by goods from third countries. Because once your rules of origin are lax, it means you are game to other countries that are not qualifying to flood goods into your country. So it's important to strike that balance when actually formulating the rules of origin. That's the allegory there of gatekeepers and tollbooths. This is actually to try and simplify what are the rules of origin and how these are related, that if you've got correct rules and you've got correct classification, then you have access to preferential treatment. A correct classification as well, you could have a tariff, or your goods, maybe if you can seemingly appear to be correctly classified, and maybe once the importation takes place, the Customs Administration discovered that no, your goods were actually incorrectly classified. And that can cause you to be denied access to preferential treatment. And we've seen actually companies closing down because what usually happens once the incorrect classification is discovered, it means a dive back into your records on for how long you've been actually importing under that particular tariff and using the certificate of origin. And because of that, we've seen businesses closing shop. And obviously, they won't close shop. They won't actually take the fight lying down. They might need to actually approach our courts to actually give a ruling on what will be happening. The most favored nation principle in relation to third-party countries can undermine the AFCFTA benefits, where state parties in agreement with third parties may inadvertently be forced to grant preferential treatment of imports from developed economies. So this is very important, as I said earlier on, that we've got rules of origin that become the gatekeepers, and we've got the tariff schedules as well. So if our rules of origin are not watertight, we can see actually third countries coming into claim because of this principle. Remember, as we discussed yesterday, that the AFCFTA is also drawn along the WTO regulations, and we find that the MFN principle is actually binding in all the countries globally. So you cannot offer a particular tariff to a certain country and fail to offer the same to another country. So it is where the rules of origin come into place so that countries are actually protected in terms of third parties coming to claim as well the most favored nation tariff rates. The other challenge is transparency from the customs union and state parties. tariffs provide fiscal sustainability, and in most African countries, depending on the level of development, you see how long it took for the countries to make their tariff offers, and even those that have made their tariff offers, it remains very opaque on what is happening, because like some countries, they've just offered in category A, and we've got maybe like 16 state parties that have managed to offer tariffs in A, B, and C. Why is that? Why is it that we have these offers actually shrouded in opaqueness? It is because countries, I'm sure they are worried that they don't want they want to open up their trade spaces, but they are doing it so carefully to the extent that in the end it doesn't become transparent. And maybe the customs union that has actually done maybe a relatively good job on tariff offers is the SACCO customs union. They have managed to complete their tariff offers, and so far we can easily access them and see what is happening there. Then the overlapping of spaghetti bowl effect poses a challenge in the application of tariff modalities and rules of origin. Yes, we have spoken about this. Yesterday it was actually discussed extensively about the spaghetti bowl effect on these several trade agreements that overlap. And this overlap, it becomes very difficult for the ordinary business people and also for the customs officers as well, in order to, when they try to apply the rates that are applicable in those tariffs that will have been applied, because you will see that there is a country is a member of the COMESA and also a member of the SADC. A country is a member of the EAC and also a member of COMESA. So the application of tariffs becomes very problematic, and maybe the application of rules of origin also becomes a challenge. I think we've discussed about how the AFCFTA is modeled. And what is important to know is that if the product meets all conditions that entail correct classification, proper supporting documents that include a prescribed certificate of origin, the DSM and appellate bodies are recourse institutions of the AFCFTA when all other interventions, such as domestic legal avenues, have failed. The state parties take up the tariff concessions or origin disputes to engage the counterpart state party. This is where our legal courts come into play to actually moderate on what will be happening, and they do issue rulings. And once a tariff ruling has been issued, it is legally binding, and for all the countries have to stick to that legal binding that has been issued by our courts. I've just shared there a situation where preference can be denied. It can be due to the failure of goods to reach the local content threshold. As I shared with you that in order for goods to qualify on to be originating, there's extensive investigation, and this investigation involves looking at the details of what actually goes into that particular product. You find that maybe someone can import maybe yarn from China and buttons from the US, and maybe fabric from a state party within the AFCFTA. Then in terms of the local content threshold, it has to be investigated and see whether the required threshold has been reached. And this can be a bone of contention whereby we see ourselves approaching the courts to actually meditate and give a ruling on that particular matter. Yesterday, I think the last presenter gave a case study on Ghana. I can't remember the details, but those are sort of cases that can actually be taken to court for the courts to meditate and come up with. And actually, the second case is an importer is charged with the most favored nation rate instead of the AFCFTA tariff rate. It's the same. It's almost the same. That maybe there is a third country involved, but maybe in terms of origin, the goods can qualify, but in terms of tariff classification, there is a deviant, and that becomes a problem as well, as the parties will thresh each other out in order to arrive at the correct tariff rate, because the correct tariff rate might actually remove them from paying the most favored nation rate which usually doesn't have a preference. Conclusion, notwithstanding the provision of fiscal stability within African countries, tariff liberalization and transparent rules of origin should be prioritized by state parties to enable the seamless implementation of the ASFTA that ushers an enabled trade environment conducive to investment and regional value chains. This brings us to the end of our discussion, and our plea is that we must not be intimidated or be put off by these tariff concessions. The negotiations are ongoing, and for a trade agreement that, like the ASFTA, which is ambitious in its nature, it will take long for us to actually reach where we want to be. But typical of trade negotiations, they take a very long time. And we must remember that Africa is running. And at this point, I would like to end my presentation. Thank you.
Big applause again, please. Thank you very much. Indeed, very practical and insightful. Now I'd like to go to Q&A. Please. Okay.
So I have two questions. The first one is something that I'm drawing from a conversation we're having about incentives to private sector, how the government uses that to measure if they give incentives, then what does the government get to benefit? Get jobs and investment. So for tariff concessions, what are some of the assessment metrics that states can use to measure in terms of if we give these tariff concessions, then what do we get in return? What are the benefits? Secondly, I was in a forum where someone made an accusation that there's a country in Africa, I won't mention the name, that the government is in cohorts with the private sector where they import things from China cheaply, and then they package it and export as their own. So is that something that any of us has seen? And if it happens, how do we handle something like that so that we don't have others taking advantage of the rest?
Thank you, Ms. Sitshengisiwe Ndlovu. I hope I managed to pronounce your name correctly. I wanted to understand the considerations for classifying the origin of a certain good.
Third question, and then she can answer the first round. There's the hand there.
So my question is how the AFCFTA rules of origin take into consideration the REX rules of origin, for example, the East African Community rules of origin, and what happens in circumstances where there's a gap, and then is there a situation where that, like, let's say a multinational corporation is doing product lines across multiple countries and that's multiple RECs. So if for a product to be created, it has to go, say, across 3 different borders, and because we have a spaghetti bowl, you might find that's possibly 3 different RECs with 3 different rules of origin. How is that managed? How is that balanced out? And how do they handle disputes when they come up?
The question on tariffs and incentives, the question was what happens if maybe if there is an importation on a particular tariff, how does the government get to know of the impact of the particular tariffs within the country? What usually happens, as I said, that with these tariff offers, it is the business, it is the private sector who actually keeps the tabs on these things. If someone is affected, if a particular business is affected, they are allowed to approach the government and share what is actually happening, because this is what we call there is an injury happening in the domestic market. But at times, businesses, at times they are afraid of competition, and someone can actually say, this is what is happening, yet they are actually scared of competition. And competition at times it is good, because competition does force prices to go down. But how does the government know as to what is happening? Because that should also be qualified. The customs administration, that's the role they play. They've got the software, like if you have heard of the Ascuda, it can actually maybe streamline, it can list a particular tariff, the duties that are being gained, the level, the volume of importations against that particular product, and immediately the government can actually come up with a picture of what is actually happening. And in instances where maybe the government doesn't take heed and thinks maybe it's ordinarily maybe someone trying to, or a sector trying to avoid competition, the market shows immediately. Maybe you run out of, maybe it's a raw material that is being affected, you run out of those commodities immediately, and the prices actually go up, and it's an indication that something is not going well, and the investigations start going that particular direction. And then you spoke about repackaging, that obviously third parties will always take advantage. And as I'm saying right now, that we have third parties actually watching what is happening with the AFCFTA. And as businesses, they would like to make profits, and they will come in and actually repackage the goods. And as far as repackaging is concerned, it's also a legal thing. There's the definition of the process of manufacture. Repackaging doesn't constitute a process of manufacture. And because of that, origin of that was the origin won't change because you've imported goods from China, repackaged them here, and exported them to a state party. Duties will come. Duties will fall heavily on that particular business. And this is where I was saying that we've had instances where business actually closed down. It's due to some of these things where people will be cutting corners to try and take advantage of the preferential rates. Then origin is very critical. There will be a lecture on rules of origin. But from what I can say right now, how is that arrived at? Origins arrived at, we've got the wholly produced goods, like the wholly produced goods. We are looking at something that is maybe wholly grown, your agricultural products, or maybe your animals. The origin there is straightforward. But in terms of manufactured goods, as I say, that there is actually an extensive, a comprehensive investigation on what entails the nationality of the goods. Remember, they have to qualify that these goods are originating from that particular country. And it's actually a process where there will be a lot of visits until the customs administration is satisfied that indeed a lot has gone into that particular product in terms of the local content. There is a prescribed rate, the prescribed local content of that particular product that is actually agreed upon. And as soon as those goods don't reach that prescribed local content, it means the origin of those goods won't be afforded to an extent that it will qualify for preference. So he spoke about the treatment of goods originating in state parties and moving through countries using different, going through different customs administrations, or maybe going through different regs, and if I got him correctly. But what usually happens is that the AFCFTA has concluded that once maybe the rates of that are being offered, remember we said the AFCFTA is actually premised on the principle of the ACWI principle, meaning that the regs as they are working right now, they can continue. But once the AFCFTA, once the AFCFTA certificate of origin is produced, if the preferential rate of duty is lower in terms of the AFCFTA, it means the rates of the AFCFTA will prevail. If the rates of the preferential the preferential rates are low in terms of what is prevailing in the regs, then the regs rates of duty will prevail.
Thank you very much for the wonderful presentation. I just want you to speak on the fraudulent use of corrupt certificates of origin, or certificates of origin that are then acquired corruptly. What is the position with respect to AFTA? And I would also want maybe to solicit the views of our sister who was involved in the negotiations, as well as Prof. Regis, if she's got something to say. This is why yesterday I was raising the issue to say, under the AFTA, there was need to have a protocol on combating of corruption, illicit financial flows, and money laundering. So I would really want your views on that. Thank you.
Okay.
Two more questions.
Okay.
Before
I actually ask my colleague to come in and assist, in terms of fraud and all the issues of corruption that arise in terms of enjoying the preferential treatment, I think trade facilitation, remember we've got Annex 4 on trade facilitation, trade facilitation actually is wide and encompassing. I'm just going to mention one, like in terms of the certificate of origin. As I say, that is still an ongoing process. We are moving towards a paperless environment. In paperless environment, it means there is scope for state parties to engage what we call maybe blockchain technology. We take care of such incidences whereby there is no interface between anyone. The whole right where the goods are originating from, that certificate is raised, and then there's no one who's got access to it. And if ever there's any tampering, immediately it shows on the dashboard that this is what has happened. And I think when with the time, with negotiations and time, this technology will actually be used. I'm not saying they're going to use it, but it's actually they were talking about it as far as in the realm of trade facilitation, that those are some of the interdices that are now in place, that trade is going digital. And blockchain technology is watertight. The incidence of corruption, as we are saying, the incident of tampered documents will be a thing of the past when we take up